Hi everyone, this is Pennsylvania attorney Evan Gutman presenting my video legal education series. The videos are based upon my book, State Bar Admissions and the Bootlegger's Son. The book is about the good moral character requirement to obtain a law license and be admitted into the practice of law. The full book is available on both of my websites, one of which is gutmanvaluations.com and the other of which is heavensadmissions.com. In addition to the initial book, the websites also include a supplement that I wrote to the book, and also the websites include a fictional novel I wrote titled Heaven's Admissions Process. The novel is kind of a humorous, upbeat novel that addresses the criteria to be admitted into heaven and compares it with the criteria to obtain a law license on earth. It's a fun book. I think you'll like it. In addition to the two websites which contain the books, I also will be presenting the videos and PDFs related to each video on my Facebook page and ultimately YouTube. Still working on getting the YouTube up and going, but they'll be on my Facebook page, my personal page, as well as a brand new Facebook page that I've started, which is titled the Judicial Constructive Criticism Network. Once again, that's Facebook, my personal page, as well as Judicial Constructive Criticism Network. So here we go. This is the first in my legal video series. We're going to cover several topics in this first episode. The first is I want to talk about a seminal U.S. Supreme Court case that basically established the manner in which the judiciary functions and the all-encompassing power it has over the other two branches as a result of a seminal U.S. Supreme Court case which is titled as MARBURY versus Madison. And quite incredibly, this case occurred over 200 years ago, approximately 225 years ago. The facts surrounding it began in 1801. The case itself was handed down by the U.S. Supreme Court in 1803. And it's really the foundation of our entire legal system and the entire judiciary branch of government. And it's also a very controversial case. The judiciary, as a result of this case, carved out for itself the sole and exclusive power to interpret the law. Now, the laws themselves are enacted by legislatures. They're enacted for federal purposes by the Congress. They're enacted by state governments, by state legislatures. And they're administered by the executive branch of government, which is headed by the president for the federal government and the governor, basically, in each individual state. So the executive branch has the power of administering the laws, i.e. by the police, various agencies, things like that. The legislatures have the power to enact the law, say basically what we're going to have as the law itself. However, when it comes to interpreting the law, that sole and exclusive power was allotted to the judiciary by the judiciary itself, not with the permission of the Congress, not with the permission of the legislatures. The judiciary itself said, this is our power. Now, this occurred in the seminal case of Marbury versus Madison, as I indicated, and I'm going to talk about how that case came to be and the quite disturbing facts around it. The U.S. Constitution was enacted in 1789. George Washington basically served 2 terms as president, and John Adams basically then served as president following George Washington. At that point in time, the judiciary did not have the sole and exclusive power to interpret the law. As a point of fact, the judiciary at that point in time was pretty much disregarded as almost a non-consequential part of government. In the Constitution itself, it was considered to be one of 3 co-equal branches, but it was clearly the weakest because it didn't have any logistical power to enforce its opinions. What happened was as follows. The presidential election of 1800 was very, very hotly contested and almost resulted in a civil war for this nation at that point in time. John Adams, as indicated, had served as president starting after George Washington, approximately 1796. So next election was 1800. Adams' vice president was Thomas Jefferson. Now it's interesting, typically in today's world we think of the president and the vice president as being part of the same political party, but at that time they did not have to be part of the same political party. And as a point of fact, the two political parties that existed at that point in time were the Federalists, which John Adams was a Federalist, and the Republicans, of which Thomas Jefferson was a Republican. So you had a Federalist president and a Republican vice president. Now, what makes it even more confusing is the Republican Party at that time was really not what became the Republican Party today. The Republican Party at that point in time actually ultimately became the Democratic Party of today. And the Federalists, to a large extent, after many years and some changes, the Federalists were basically the forerunners of the Republican Party. So you got this hotly contested election in 1800 between Adams, Jefferson, and a third candidate, Aaron Burr, with electoral votes basically deciding who becomes president. What occurred was Jefferson and the third candidate, Aaron Burr, actually tied. John Adams was a distant third, even though he had previously been president. As a result of Jefferson and Aaron Burr tying, the election went to the House of Representatives. And after 35 ballots, they were still tied. So the House of Representatives could not decide on who the president was going to be. On the 36th ballot, a representative from Delaware changed his vote to an abstention, and as a result, Jefferson won the election. So Jefferson, who was a Republican, becomes president. John Adams, who at that point in time was his fierce rival, becomes essentially a lame duck president until he's going to leave office. When John Adams leaves office, he does kind of a tricky little thing, which is right before he leaves office, he appoints a large number of individuals to be judges. And those judges, who were obviously all Federalists because John Adams was a Federalist, those judges became known as the Midnight Judges. And this is a famous event in U.S. history because the question becomes whether they were legitimately appointed or not. And the reason the question becomes whether they were legitimately appointed and should take office is that although John Adams appointed these individuals to be justices, the commissions that basically, the piece of paper that made him a justice, was supposed to be delivered by John Marshall. Now, John Adams appoints John Marshall to be Chief Justice of the U.S. Supreme Court. But before Adams leaves office, and before John Marshall becomes Chief Justice of the U.S. Supreme Court, John Marshall was supposed to deliver these commissions for the Midnight Judges to become judges, and he doesn't do it. When Jefferson and Madison come into office as the new president and James Madison being Secretary of State, the commissions for these judges are literally just lying on a table. They're just lying on a table undelivered. And the individual who was supposed to deliver those commissions was John Marshall, the new Chief Justice of the U.S. Supreme Court. So what happens is a man named Marbury, who was one of the judges to be appointed, he sues to get his commission. And the case is going to go to the U.S. Supreme Court, which is effectively going to be decided by John Marshall, who is the individual specifically who was supposed to deliver the commissions in the first place. So at that point in time, the U.S. Supreme Court is really considered a fairly weak government. And although John Marshall, being a Federalist, you'd think would want Marbury to get his judgeship, he knows that the president, the new president, his fierce rival, Republican Thomas Jefferson, won't deliver the commissions, even if Marshall orders him to. So Jefferson basically is just treating the U.S. Supreme Court like a piece of garbage. Marshall orders the new Secretary of State, Republican James Madison, to appear before the court. Jefferson tells Madison, just ignore him, don't go. So essentially kind of spitting in the face of the U.S. Supreme Court. James Madison doesn't even show up. James Madison doesn't even show up. And Marshall's in a position where, as a Federalist, he was supposed to deliver the commissions. He kind of wants the Federalists to be in there. It's never really been explained why he didn't deliver the commissions. And what Marshall does is he pulls off one of the most brilliant and also nefarious and deceptive maneuvers in American political history ever. Knowing full well that he can't take on Jefferson and that Jefferson will never deliver the commissions, what Marshall does, he himself, even though he was supposed to deliver the commissions, he basically says the only way this commission can be valid is if the statute that it was enacted under, which was the Judiciary Act of 1801, was valid. And so what Marshall does is he declares the Judiciary Act of 1801 to be unconstitutional, thereby allowing himself to save face because Marbury doesn't get to take office even though he's a Federalist. And Jefferson basically doesn't care. Basically, Jefferson, all he cared about was not wanting Marbury to be in office or any of the other midnight judges. The way Marshall basically accomplished this maneuver is, in his opinion, he asserts that it's the sole and exclusive province of the judiciary to determine the constitutionality of a statute. So essentially what he did is he gives Jefferson the small win. It appeared to be the big win at the time, which was that the judges didn't get to take office. But in all fairness, it was really the small win, because what he did is he established in American history a case that stood for the proposition, and is still valid law today, that the judiciary, in this case the U.S. Supreme Court, has the sole and exclusive power to interpret the law. And once you have the power to interpret the law, as we've seen in today's world, it's ultimately discovered that the power to interpret the law is immensely more important than the power to enact law that Congress has. It's immensely more important than the power to administer law that the executive has, because the power to interpret law is effectively the power to make law. And the reason for that is the way the law is interpreted is by defining words. And once you can define the words that are in the statutes to mean anything you want, then you have the power to make law, because the words that Congress wrote don't mean anything. It's the words that the U.S. Supreme Court uses to interpret the words that are actually become the mechanism by which the executive administers the laws. So remember, the power to interpret the law is the power to make law, and it virtually neutralizes Congress as well as the executive branch, because the law becomes exactly what the judiciary says it's going to be. And this all occurred because John Marshall, approximately 225 years ago, pulled a fast one in Marbury versus Madison by giving Jefferson the win by declaring a statute unconstitutional and carving out that the only branch of government that has power to declare statutes unconstitutional is the judiciary branch of government. Thanks so much for watching, and we'll do the next chapter, next session of the video within the next day or two.